Okay, today we're taking a look at a 23-year-old who was busted with a firearm and put on probation. He violated his probation multiple times and is being charged with possession of methamphetamines. He had an intent to distribute, and now he is back in court. How will this judge handle this criminal?
Joanna Carey, Chief Assistant Prosecuting Attorney for the People.
And I'm Jeff Harrison. I'm here on behalf of Mr. Noble. He's going to get the table.
Thank you. Also here before the court this morning is Mr. Kevin Stapleton from the Michigan Department of Corrections, serving as the probation officer today in this case. We are here for a formal hearing on this probation violation case. Let me find the warrant here on the file. Looks like we conducted an arraignment with the defendant who was back up in Sheboygan County Jail back on August 21st. It looks like there are 2 counts. Mr. Harrison?
Indeed, Your Honor. We understand resolution of this case. There'll be no need for a hearing. I'll defer to the prosecutor.
Ms. Carey?
It's my understanding he's going to plead no contest to count 2, and the people will dismiss count 1.
Thank you. Do we have a police report?
I have an affidavit of probable cause from Sheboygan County.
Let's go ahead and have that, Mark. Mr. Harrison, is that a complete and accurate statement today?
It is, Your Honor. I apologize for the confusion on my part.
It's okay. All right, Mr. Noble, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth, sir? Lower your hand. All right, Mr. Noble, you are currently charged on a request and warrant for a probation violation with 2 counts. Count 1 is that you violated condition 2.4 that requires that you must not use or possess any controlled substance, and allegedly on or about August 11, 2024, you possessed methamphetamine. That's a technical probation violation. I will explain the importance of technical versus non-technical in just a moment. Count 2 alleges that you violated condition 1, which requires that you not violate any criminal law of any unit of government. And more specifically, it's alleged that you violated Michigan law by possessing methamphetamine on or about August 11th, 2024. Now, if you enter a no contest plea, which is what the attorneys have told me you intend to do, you'll not have a hearing of any kind. A no contest plea has the same impact as a guilty plea. The difference is, however, that instead of requiring you to recite a factual basis, I will look at something else, such as what is currently marked as People's Exhibit number 1, which is an affidavit from a probable cause, apparently prepared by a Sergeant Michael Hecko, Hecko. And I will use that to determine if you are guilty. You understand? Now, by pleading no contest, if the court accepts that plea, you will not have a formal or contested hearing of any kind. You will be waiving certain rights that you would otherwise have at a contested hearing. That includes, again, the right to have that hearing, the right to have the prosecutor prove the allegations by preponderance of the evidence, the right to question and cross-examine any witnesses presented against you, the right to review any evidence presented against you, as well as the right to present witness evidence or testimony if you chose to do so. Then, of course, at that hearing, you would have the right to remain silent and nothing would be used against you for that exercise of that right. So far, do you understand?
Yes, Your Honor.
Now, if you are found to be in violation of your probation, you'll be resentenced on your original offense. In this case, you were originally convicted of larceny of a firearm. Was that as an attempt? I think it.
Correct.
All right. As an attempt, which is a felony punishable by up to 2.5 years, or in other words, 30 months, and up to $2,500 in fines plus costs. Have we had prior probation violations?
Yes.
I think we have. Your case looks like you had some prior technical violations. In the technical violations, the court's limited to a sliding scale. For 1, the court's limited to 15 days. For 2, the court's limited to 30 days. 3, the court is limited to 45 days. For 4 or more, or for non-technicals, the court's no longer limited to that sliding scale. and is only limited by the amount allowed under the law for the original offense of which you were convicted. Now, this count 2 that I'm told you're going to plead no contest to is a non-technical, which means the court will not be limited to that sliding scale. Do you understand, sir?
Yes, sir.
Mr. Noble, therefore, as to count 2 on the request and warrant for the probation violation, which was dated August 14th of this year. Thank you. Mr. Harrison and Ms. Carey, I understand. Hey, Ms. Harrison. All right, good. Is the basis for the no contest plea based upon potential criminal liability in the other county?
It is, Your Honor. There'll be more on that later.
All right, thank you. Mr. Harrison, I have now this People's Exhibit number 1. Do you stipulate, does the defense so stipulate for its use today for the taking of the plea and the sentence?
I do. You do.
The court hereby admits People's Exhibit number 1. Again, this is an affidavit of probable cause prepared by Sergeant Michael Hecko, again, Hecko, and it consists of 3 pages. Ms. Carey, do you believe this provides a factual basis for the support of the plea of no contest to count 2?
I do.
Mr. Harrison, do you agree, sir?
I do agree.
Ms. Carey, are you aware of any other promises, threats, or inducements?
I'm not.
Mr. Harrison, how about you?
Nor am I.
I forgot to ask you that question, Mr. Noble. Have you entered this plea of your own free choice?
Yes, sir.
Have there been any other promises, threats, or inducements that I haven't heard about yet?
No, sir.
Ms. Carey, do you believe the court supplies the court rules so far? Mr. Harrison?
I do concur with that as well.
The court agrees, and the court finds the defendant's plea to count 2 on the request and warrant is made freely, knowingly, and voluntarily. The court further finds that based upon the issue of potential criminal liability in another county, the interests of justice do not require the defendant to recite a factual basis today. The court further finds that upon review of these 3 pages in the affidavit that I mentioned, provide a factual basis to support the plea of no contest and for the defendant's possession, knowing possession of the controlled substance methamphetamine. Therefore, the court finds the defendant guilty of count 2 and dismisses count 1. Mr. Stapleton, are we able to proceed to sentencing today?
Your Honor, we would actually request that sentencing be advanced in this matter because of the pending charges in Sheboygan.
Advance, you mean adjourn?
Adjourned, yes.
Okay. The court therefore probably will not dismiss count 1 until we get to the sentencing.
That's fair.
Because that would not be appropriate. All right, so the court will dismiss count 1 at the time of sentencing. The court's also going to ask Mr. Stapleton, do we need a CFJ 491?
I don't believe so, Your Honor.
Okay, what was, I think I looked earlier, was his last sentence 156 days? Is that what I recall? That might have been in one of the other cases that you're here for today.
I think this last sentence here was 17 days.
Okay.
17
On the
credit.
PV.
Right.
Yeah.
Okay.
Probation violation.
Well, what did he score on his,
0 to 9 months.
what do you have for prior PRV points?
10 PRV points.
All right, so he had very little on there. Misdemeanors probably. Is that what he scored?
PRV 3.
3. All right, thank you. All right, well, the court's not going to direct the Department of Corrections then to prepare a written probation violation report, again, also known as a CFJ 491. Mr. Noble, are you currently being held? I know we had you transferred here today via a writ. Are you also being held up in Sheboygan County at this time?
Yes, sir.
Mr. Harrison?
Well, just in addressing that, Your Honor, there is a bit of a dilemma. He has the opportunity to get into rehab from Sheboygan County. It's simply a matter of him having a hold here, and I believe he was remanded. I believe it would likely be considered premature if I were to ask for PR bond here today without a firm grasp on the other arrangements. I'd simply like to tee that up, and that may be a request in the future. If Sheboygan County is able to supervise his release to treatment, Would the court accept a stipulation to reduce bond to PR? Complete disclosure, of course.
Yeah.
Mrs. Carey, I'll hold my feet to the fire in that regard.
Mr. Stubbleman, I quickly reviewing the file, I see the defendant has had at least 2 different probation violation sets. Am I correct?
Yes, that's correct.
All right, and both of them involve use and or possession of controlled substances. Is that right?
Yes.
Okay. And I think one of them was he was unsuccessfully discharged from Harbor Hall. Has the court in Sheboygan County already modified their bond and approved that he be released to a treatment program on a specific date?
Not on a specific date, but the short answer is yes.
Okay,
But they were aware of his hold in Wexford County
all right.
and that we could likely do something with that today.
Ask you today to modify his bond then?
I would if you were willing to do so,
Ms. Carey,
reluctantly so perhaps.
Ms. Carey, your position?
Frankly, without more information,
Yeah.
people would
Okay.
oppose it because
You would oppose the request today, but maybe if with further information.
maybe, I mean,
Okay.
he has a history of absconding, of probation violations, of leaving. The charges in Sheboygan County are possession with intent to deliver. He was caught in a car coming back from Flint, admitted that with
Yeah.
drugs. So, yeah, I would oppose it today.
All right. I'm not inclined to do it today, but if the parties enter a stipulation and I've got a specific date, time, bed, the court could. Mr. Noble, I want to explain something to you because if the parties do a stipulation, which is generally written and then submitted to me, it will have a hook to it. And that is, and by the way, you won't see me again if that, at least not until sentencing, if that happens. If I sign it and allow you to go to a program, your success or lack of success in that program will definitely go a long way with the court. Now, by the way, I want you to know something. If I do that, you are not to interpret, and you're not to interpret for my allowing you to go to a program as a promise of no further jail. Because I'm a firm believer that jail confinement serves a purpose. Maybe some people can argue statistics to me, but I believe it provides a purpose. And sometimes it's to keep people who have substance abuse problems away from the people that are influencing them, the people that are providing it to them, the people with whom they are sharing and using those substances. So I am more than willing to lock people up. What I want, but that's also not a promise that you're gonna get jailed. The point there is if I later on sign a stipulation to allow you to go to that program, I don't care what Sheboygan does if you leave. I know what I'll do. When I say I know what I'll do, I mean, I'll issue a bench warrant. I don't know what the sentence will be. I don't make any predetermination.
Understood.
Yeah, I just don't want you to, I don't want anybody to come back and say Judge Elmore is inelastic in his opinion. I'm just saying, but you'll get a warrant. That's for certain.
Gotcha.
All right. So today we found you guilty of count 2. Count 1 will dismiss at the time of sentencing. I'm going to let you go today. I'm going to deny any modification of bond today, which is because the prosecutor has a right to receive a written notice of a motion to modify bond. And since she doesn't have it, the court clearly needs to respect that court rule and will deny the bond modification today. If there is a modification, the parties can submit it to me. All right, I've already said enough on that. Anything else, Mr. Harrison?
Nothing further, Your Honor. Thank you for your indulgence.
Thank you. Anything else from me today, Ms. Carey?
Yes, sir.
Mr. Suppleman?
No, Your Honor, thank you.
All right. Mr. Noble, do you have any questions about what we have done today or what I have said today? All right. Mr. Noble? 23. Okay. 23. You're young. Stop doing stupid stuff. Right. By the way, my wife and I recently bought our son, who does well at everything. He's a pretty good kid, but it says, "Don't do stupid." And my wife put a different word on the end. But anyways, let's make good choices. Thank you. We're adjourned.
Let me know what you think about this case in the comments below. If you like this video, consider liking, consider subscribing. Until next time.